Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shara bin Jamal Fazli. My matrix number is 2020984673. So today our group 3, will present about the topic that related to Munakat matters, and our group will carry out the two issues, which is first issues we will bring out about the topic that related to the breach of contract to marry, and the second issue is the topic that related to Fasakh due to Darar. Alright, first thing first, let's go to the definition. Let's see to the definition first. And alright, I want to let you know about the definition of the breach of contract to marry. I mean the behind the scene before the marriage happened. So first thing first, of course, the people will make a ceremony which led to wedding, which led to marriage, and which called as peminangan in Malay, or engagement in English. Meanwhile, in Arabic word, we call it as al-khidbah. Alright, al-khidbah in terminologically means a man who propose his desire to marry a woman. Meanwhile, in etymologically, it is asking a woman to be his wife. Alright, let's see what is the objective from al-khidbah. Alright, al-khidbah is it is important to all human beings because it is to bring a blissful and harmonious marriage. Okay, because during peminangan phase, during al-khidbah phase, both parties can see how far their compatibility of a relationship, and during this phase, both parties can getting to know each other well. And despite of building a harmonious and blissful family, al-khidbah is very significant things to do before someone to move into a marriage phase. And also, Allah subhanahu wa ta'ala has encouraged people to do a khidbah before doing a marriage. And in Surah Al-Baqarah, verse 2, in ayah 235, which means there is not wrong upon you if you make an offer to propose a woman in kinaya, in sarcasm way, those have died a husband or still in iddah, or you keeping your heart to marry her. Sadaqallahu al-Azim. So through this dalil, we can see that Allah subhanahu wa ta'ala has mentioned about al-khidbah, and it is not contrary to Shara. Alright, let's see to the law of giving gift in engagement. Alright, let's see, is it okay, is it fine to give your partner a present in engagement ceremony? Right, let's see to the view of the scholars that related to the giving gift in engagement. Alright, first, Hanafi said if the gifts are still intact and unchanged, then the giver can request back their gift. But if the gift has changed from the start, then he has no right to get back all the gift given by him. That is the views from the Hanafi. Meanwhile, in Maliki said if the breach is committed by man, then the man has no right to seek the return gift by a woman. However, if the woman is committed by the breach, then the man would have right to request their gift back. Alright, so that is the Maliki's views. Meanwhile, in Shafi'i views, in Shafi'i said if there is a breach of a betrothal, then the gift should be returned whether they still exist or not. So it means whether he or she need to pay back all the value that related to the gift, and he or she also need to give back, to return back all the present that giving to him or her. Alright, meanwhile in IFLA is the Islamic Family Law Act. In section 15, in IFLA stated that if any person has either orally or writing or in either personally or through an intermediary enter into an betrothal according with the Hukum Shara, and subsequently refuses without lawful reason, and subsequently cancel the engagement and marry to the other party, then the other party have liable to have a written gift, or the other party need to pay whatever monies that have been expended in the preparation of the marriage. So that is stated in the section 15 on IFLA. So in these cases, if any person found a reasonable reason to cancel the marriage, the engagement, then he or she do not have to meet the both claim described by section 15, and they do not demand any act to the Sharia court. Alright, let's move to the other slide, which related to law annulment of engagement. The law cancellation of engagement. Is it fine to cancel an engagement? Alright, let's see. According to Said Sabit, he said an engagement is only a promise to commit a marriage, so it is not bound contract for both parties. So every party has the right to cancel their engagement if they found a reasonable reason to cancel their marriage. In Surah Al-Ma'idah verse 1, Allah Subhanahu wa Ta'ala has said that Ya ayyuhalladhina amanu awfu bil uqud, which means, O believers, fulfill your promise, honor your bonds. Sadaqallahul Azim. So Allah Subhanahu wa Ta'ala has obliged to all people, to all Muslims, to fulfill their promise, even though it is not a bound contract. So in these cases, if someone found a reasonable reason to cancel the engagement, then they do not have to commit, or they do not have to claim the described from the Islamic Family Law Act that stated in the section 15. But however, from my opinion, to prevent any losses occur, it is better to a party to cancel earlier before the other party makes any preparation to hold a wedding ceremony. So I think that's all from me, and I will pass my presentation to Fatin Nur Atira.
Assalamualaikum warahmatullahi wabarakatuh. So my name is Nur Fatin Atira binti Muhammad Anwar, and my metric number is 20207557. So I will continue this presentation about law of claims due cancellation of engagement according to Islamic law. So basically, in general, when an engagement is cancelled, a common question that arises in society is whether the party who decided on the engagement can claim compensation against the party who decided on the engagement under Islamic law. This is because in this contemporary era, the Malay custom of providing a magnificent fiancé delivery to their fiancé has become a traditional of the Malay community, especially those who can organize large-scale engagement ceremonies. Furthermore, it is customary for the Malay Muslim population of Malaysia to make different preparations during the engagement time before the date of the marriage contract, such as paying the cost of booking the hall, meals, wedding dress, house repair, and others. From a moral point of view, the sentiments and dignity of both parties should be considered. Alright, so there are situations where a man's or woman's good name is tarnished after a long engagement. Like say for 4 years, yet the engagement is suddenly cancelled for no apparent reason. That's why there are scholarly arguments about the rights of people who have agreed to marry, such as discussions of gift claims during engagement and compensation claims for wedding preparation for breaking a vow to marry. Okay, so the first of law of claims due cancellation of engagement according to Islamic law is return of engagement grant. So let's see, the Hanafi and Zahiri sects are of the initial view that the giving of engagement gifts should be withdrawn. Okay, this sect argues that gifts are governed by the rules of hibah, and anything that prohibits hibah from being returned also precludes the right to return an engagement gift. Okay, so if the engagement gift is still there and the ain is still there, the ain of the gift must be returned. The second view is from the scholars of the Maliki and Hanafi sects, think that no authority can cancel a gift whether it is ain or not. Okay, so these scholars of this group believe that the gift of delivery is a hibah and the hibah cannot be returned once it has been reserved. Okay, so let's see the third view held by Mazhab Shafi'i and Hanbali is that a man is not entitled to get back the gift that has been given to the woman, regardless of whether the item is still there or not. This is because the gift of the gift is considered a present by Shafi'i and Hanbali sects, and the gift cannot be withdrawn until the hibah is from the father to his son. The fourth position of the Maliki school is that it is important to return the gift of engagement, and has separate this issue between the cancellation of engagement caused by man and woman. If the cancellation is made by the woman, the engagement gift from the man must be returned, and vice versa. Okay, so let we see about the second law of claims due cancellation of engagement according to Islamic law, which is claim for the compensation due to cancellation of engagement. So the first one is from Sheikh Umar Sulaiman, Sheikh Muhammad Al-Sartawi, and Sheikh Muhammad Baqir Al-Muti'i. In their initial view, believed that there was no claim for damages, whether material or general, as a result of the termination of the engagement. Okay, so this view is based on the fact that the engagement is white-wired, which is like promise that cannot be fulfilled or is not legally binding, and not akad, okay, which is a legally binding contract. Okay, consequently, both parties were informed that no compensation could be claimed if the engagement was cancelled. So let's see the second view of from Abdul Ar-Razak Al-Sanhuri, Dr. Wahbah Al-Zuhaili, Abdul Ar-Rahman Al-Sabuni, and Usamah Umar Sulaiman said that claims for losses after the cancellation of an engagement, whether material damages or general damages, were allowed. Okay, so this is because the bond of engagement is formed upon the agreement of both parties, and the acceptance of the engagement is present as a show of a commitment. If the engagement is cancelled after the bond is complete, the termination will be detrimental to both parties. Let's see about the third position is from Muhammad Abu Zara and Mustafa Al-Sibai, who think that claims for damages as a result of the termination of engagement are valid, but only for material damages. Okay, okay, so what I found is researchers believe that only financial damages can be claimed from the party who decided on the engagement, because cancellation of the engagement would result in harm, and a claim for financial damages is a way to mitigate that loss. Finally, the Maliki set thinks that if the party who pledged has met the promise criteria, the party who cancels the engagement must pay compensation based on the concept of accountability. In this case of an engagement, if the woman has tried to make all the necessary wedding preparation in hope that the man will marry her, she is entitled to a reward for her effort. Okay, so this view is also in line with a notion of the Quran in Surah Al-Isra, verse 34, which states that every Muslim is responsible for keeping his promise, whether to Allah or peoples. Okay, so what we can conclude is overall this research has discussed engagement compensation claims that may be made by Muslims who have breaking their pledge to marry in Malaysia using both Sharia and civil law rules. So most importantly, Muslims must fulfill all the promises made, including the part of participation. If there is maslahah or masyakkah during the engagement phase, both parties should have a good and acceptable discussion until the end of the engagement to avoid misunderstandings. So Islam also allows the breaking of an engagement ring, but only based on the inevitable darar syari'i. So that's all from our group. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Aisyah binti Azman, matric number 2020987711. So for the next issue, I will explain about the fasakh due to darar. What's meaning of fasakh? So let's look at the definition of fasakh. First, fasakh is defined as void or dissolve. So the purpose of the use of fasakh in marriage is to remove the harm inflicted on the wife. When fasakh is attributed to marriage, then it is the dissolution of the marriage. This fasakh is a marital bond that is no longer suitable and causes various problems to arise, which the problem has been allowed by a court order or qadi through the method or means of dissolution of marriage for the couple in order to escape each other from the marital bond. So the description of the dissolution of marriage or fasakh is not explicitly stated in Quran. Yet it can be seen in Surah Al-Baqarah verse 231 and An-Nisa verse 35 on its principles. However, fasakh is accepted as one of the ways to dissolve a marriage between husband and wife based on the principles contained in the hadith of the Prophet sallallahu alaihi wasallam, which reads La darar wa la dirar, which meaning is there is no harm and cannot harm. So the view given by Abdul Wahab Khalaf on fasakh is to annul a marriage or restrict its continuity. Such an understanding has been supported by Ibn Manzur, who explained that void, which is nakoda, or dissolve, which is faraqah, is the meaning of fasakh. So for the next slide, about the fasakh in Islamic jurisprudence. So the things that require fasakh for husband and wife in Islamic law differ from one section to another. So according to Hanafi, only when the husband to whom the wife is married suffers from a disability and disgrace which only allows such a wife to apply for dissolution of the marriage. Only 3 diseases were mentioned, which is impotence, amputation of the penis, and the amputation of 2 penis. Other than disease not mentioned, a person cannot apply for fasakh for other reasons on her husband, even if the husband has hair loss and leprosy. For the Shafi'i and Maliki, they said that does not allow this fasakh as it is in the category of khiyar al-bulu. So they are principle that any shame or illness faced by the husband can affect the sex relationship between them or can be contagious to the wife and fetus. Then the wife can apply for fasakh. Next is about the basis of fasakh law. So the law of fasakh is basically permissible or permissible, which it does not enjoin and does not forbid. Yet it is appropriate when looking at certain circumstances and forms with the certain circumstances and forms. The particular circumstance he means in that the fasakh can be done on several factors that enable it. Among the factors are quarrels between husband and wife that cannot be reconciled, fasakh because of disability, fasakh because the husband does not have the ability to provide maintenance, and fasakh because the husband leaves his permanent place and knows his existence for a long time, and also fasakh due to breach of marriage agreement. So, as the word of Allah found in Surah An-Nisa, verse 35, which he explained about the fasakh. So the meaning is that if you are worried that there will be a dispute between the two, then send a hakam from the male family and hakam from the female family. If the 2 judges intend to make repairs, surely Allah will give tawfiq to the husband and wife. Surely Allah is knowing, aware. Therefore, based on the above description, to break a marriage bond between husband and wife, fasakh is a legal alternative that is legal and recognized in Islam. This fasakh is recognized as legal based on the understanding on the basis of the law of the Quran and also the history of hadith. It can be seen that the obligation to perform fasakh on certain circumstances. In addition, based on the word of and the hadith above, the jurists have determined that if in the life of the husband and wife has happened something that can cause harm to one of the parties, then the party who suffered harm can take the initiative to decide the marriage. Then the judge announced the marriage on the basis of the complaint of the affected party. Next is about the consequences of fasakh law. First, the husband and wife have to use a new covenant if they want to renew the marriage. This is because the marriage bond that was broken for a while was caused by the fasakh. Second, the number of talaqs owned by the husband will not decrease that number. Third is it is not obligatory to muta'ah if the divorce through fasakh occurs before dukhul, which is a relationship between husband and wife. However, if the husband is kind, then he can give muta'ah to the wife. Muta'ah is a sum of property that must be handed over by husband to his wife, whom he has divorced while living by way of talaq and contemporaries with him. Fourth, when the occurrence of fasakh because it is proven that it is defective after performing ijma', then the husband is obligated to give the dowry immediately.
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Tengku Nur Ilham binti Kumuraid, matric number 2020950861. So I will continue the presentation, which is about the reason of the occurrence of fasakh. Okay, so there are 4 reasons of the occurrence of fasakh, which is the first reason is husband does not provide maintenance. Okay, so the marriage contract between husband and wife give rise to right and obligation between one another. Among the obligation is the obligation of the husband to provide for his wife, as Allah Subhanahu Wa Taala says in Surah Al-Baqarah verse 233, meaning the obligation of the father to feed and clothe the mother in a ma'ruf manner. A person is not burdened except according to his level of ability. Let's not a mother suffer misery because of her child, and a father because of his child, and the heirs also have such an obligation. As for the proposition that maintenance is obligatory based on sunnah of the Prophet Sallallahu Alaihi Wasallam, meaning from Hakim bin Muawiyah al-Qashiri, from his father said, O Messenger of Allah, what is the right of one of the wife of us, her husband? Rasulullah SAW said that give him food according to what you eat, and give him clothes according to what you wear. Get food and clothes, and do not hit his face, do not disgrace him, and do not leave him except at home. So the verse and hadith are evident on the obligation of a husband to meet the needs of his wife, and in terms of food and clothing needs in accordance with the appearance of the above verse and the evidence that have been agreed by the scholar. Okay, however, if the husband does not provide maintenance because he is poor, then the wife demand to the judge that she be divorced from her husband. So then in this case, the juries are differ. According to Maliki and Shafi'i, it is argued that a judge can divorce between husband and wife based on the wife lawsuit. Okay, because the husband is unable to provide external maintenance. The reason is in accordance with the word of our God Almighty, Surah Al-Baqarah verse 231, meaning do not consult them wife to harms. So this verse explain that the husband prolong the woman period in iddah. Okay, meanwhile, Hanafi scholar of truth is one of the opinion that the wife does not have the right to seek divorce, and the judge also do not have the right to decide on divorce between the husband and wife on the grounds that the husband is unable to provide maintenance. So the strong evidence that support of Hanafi scholar is the word of Allah in Surah Al-Baqarah verse 280, meaning when he is in trouble, then he should wait until he is in ease. If you give harm, it is better for you if you only know. The above verse explains that every debtor who is in difficulty should be given a tempo until he is in the field. Because the husband in trouble, the wife is asked to be patient until the husband get enough sustenance. Therefore, the Hanafi school is of the opinion that the inability of the husband to provide maintenance cannot be used as a reason for the choice of Fasakh. Alright, so the second reason is Fasakh due to defects. So the disability in question is a physical disability and spiritual disability that cannot be eliminated or can be eliminated but over a long period of time. Okay, so the disability may be a physical illness, a spiritual illness, or a common disability. So that one or both spouse argue that they will not be able to achieve the goal of marriage because of the disability. Therefore, the husband can choose to divorce his wife by fasakh or continue the marriage. Juries differ on how to use disability as a reason to break a marriage. The Hanafi scholar argue that the khiyar fasakh should not be valid due to physical disability unless the husband is impotent or has his genital amputated. According to Shafi'i and Maliki, the disgrace that allow for a wife to claim fasakh from her husband is a jub, unna, jazam, junun, unsa, and also al-bara. Okay, although the scholar have different opinion about any defects, this is that can be used as a reason for a wife to ask for fasakh. But in principle, it is a disease that causes danger of suffering to the wife. can be submitted in the form of fasakh. Okay, so reason number 3 is husband commits cruelty. In this regard, the juries differ. According to the Maliki scholar, it is held that the wife has no right to seek divorce from the judge when she alleges that the husband has abused her so much that she is not willing to be with the husband in the marriage. The above information can be understood that the judge can dismiss the husband and wife based on the wife lawsuit because her husband harmed or abused her. So why the Hanafi scholar of truth is the opinion that her husband who's disregard his wife right, which has been prescribed by the Sharia such as maintenance and does not do good in association, or the husband beat her and criticizes her, then the wife has no right to demand fasakh. Then it can be understood that the wife has no right to seek divorce, nor can divorce be granted for reason of abomination or endangering the wife because the harmful act can be punished with ta'zir or require the wife to disobey her husband. Okay, so the last reason of the occurrence of fasakh is husband of the unseen, al-mafqud. What is the mean of the unseen husband here is that the husband left his permanent place and it is not known where he went and where he has been for a long time. The invisibility of the husband in this form complicates the life of the abandoned wife, especially when the husband does not leave anything to support the abandoned wife. So in this case, Imam Abu Hanifah and Shafi'i follow the opinion of the Ibn Mas'ud companions regarding fasakh because of the supernatural husband, where he argued that the judge should not decide the marriage. The wife whose supernatural husband is still born to her husband until there is a belief about his death.
Next is about the consequences of fasakh law. First, the husband and wife have to use a new covenant if they want to renew the marriage. This is because the marriage bond that was broken for a while was caused by the fasakh. Second, the number of talaqs owned by the husband will not decrease that number. Third is it is not obligatory to muta'ah if the divorce through fasakh occurs before dukhul, which is a relationship between husband and wife. However, if the husband is kind, then he can give muta'ah to the wife. Muta'ah is a sum of property that must be handed over by husband to his wife, whom he has divorced while living by way of talaq and contemporaries with him. Fourth, when the occurrence of fasakh because it is proven that it is defective after performing ijma', then the husband is obligated to give the dowry immediately. There are several consequences of fasakh to be inflicted on husband. First, consequences of fasakh against to the husband, which fasakh will bring consequences again of the husband, even if the one asking of the fasakh is the wife. An example is when a husband wants to return to his ex-wife, then he needs a new marriage contract. In other words, even if his ex-wife is still feeling in iddah, the husband cannot refer. Next is the consequences on the wife. When the fasakh occurs, the wife must perform iddah like other forms of divorce. The wisdom with the existence of iddah fasakh is to know the cleanliness of the uterus of a human who has been divorced or due to the death of her husband, so that one's lineage does not mix with others. In addition, it also provides an opportunity for the separate woman to improve herself from a home life that may be beneficial in the future.
For this issue is the first, Islam provide the way how a marriage should be administered to maintain the harmony of family life. Okay, however, when the marriage can no longer be safe and it does not meet the objective of the marriage, then it is allowed to end. Basically, separation and divorce is not a preferred option in Islam, but for the good of all parties and the well-being of a family, then that time when divorce must be required or implemented. So point number 2 is divorce by talaq. Is the best way that is organized, that is the husband and wife separate in a dignified manner. But in some case where a good divorce cannot be obtained, either because the husband refused to divorce the wife, or the husband is spared, or for other reasons that are justified according to Sharia, then Islam allow the right of women to break the marriage born through fasakh. So the last point is the provision of fasakh in Islam is intended to balance the right of women as a weak race and often fall a victim to men who take advantage of this weakness. However, the wife cannot abuse the fasakh, tend to free herself from responsibility in marriage when those responsibilities have been fulfilled by the husband accordingly, while the husband cannot abuse the marriage born by treating his wife beyond the limits of the law set by Allah subhanahu wa ta'ala. So I think that's all presentation from our group. So thank you.